All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for argument in our civil number 17-395, Renee LONCAR versus Doug DUCEY et al. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal argument. Counsel, as you know, you'll keep track of that for yourself. We've read the briefs and conference this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellant may proceed.
May it please the court, my name is David Abney, representing Renee LONCAR. I don't know if the exact facts of this case would ever be reproduced because of the odd timing of the district court injunction, its cessation, and the death of an insured person in the middle of that process. But the correct interpretation of this constitutional provision is very important. It spins on what is meant by the word sex. We contend it's simply used in its normal, everyday biological sense and not to mean something like sexual orientation or sexual preference or gender or any of the other varieties.
But is that even the right question to ask? I mean, let's say you're right about that. Is the right question whether there is a classification based on gender or anything else, or is the classification based upon a relationship?
No, the class. Well, I start with the constitutional clause, the Arizona constitutional clause, the Article 2, Section 36, and it just says sex. It doesn't say anything about sexual relationship or sexual preference.
I know that's what the Constitution says, but we have to make sure we're applying the right provision to the right facts. And here, I just question whether the classification even implicates that section, or whether it implicates a more traditional equal protection analysis.
Well, I think that probably, I submit that the best way to analyze these kinds of situations is to go with the narrowest constitutional clause and then work your way out. And if you're entitled to relief under the narrowest constitutional clause, which would be Article 2, Section 36, then after that you could go on to due process, equal protection, and other constitutional protections.
And I guess I look at it methodologically as start with the facts and then move to the law.
Well, the facts are that if Renee LONCAR had been a man, she would have had life insurance on her domestic partner. And if her domestic partner had been a woman, she would have had life insurance protection on that domestic partner. But because she is a woman instead of a man, and her partner happened to be a man instead of a woman, that's where we are. And it's solely and exclusively because of her sex. The definition, I think and
it's solely and exclusively because she wasn't in a relationship with another woman.
Well, it's not. It talks about the regulation in effect at the time talks about a domestic partner, and it doesn't have to be a same sex, different sex. Could be asexual entirely. It has some very interesting requirements. If you look at Arizona Administrative Code R2-5-101, subpart 2.2, and it talks about you have to share residence for 12 months. You have no other domestic partner. You're not currently legally married or legally separated. It's not somebody that you could. How do you say this? It can't be somebody that you could not marry. For instance, you can't have as a domestic partner your sister or your brother, because you can't marry them under the law. Maybe a third cousin twice removed would be about the best you could get. It can't be in the pool where it would be, what's the word for marrying somebody? Anyway, for marrying somebody you're not supposed to marry because of the too close in blood. 18 years old and financially interdependent. Has nothing to do with sexual practices, sexual preferences. You can be homosexual, heterosexual, asexual, non-sexual, transgender, anything in the rainbow of what human beings can be as far as sex is involved. It just doesn't matter. It could be two maiden aunts living together. Well, not maiden aunts, 'cause that wouldn't work because they're too close. But it could just be, the odd couple, Oscar and Felix, that sort of thing. It has nothing to do with sexual preference. And why this thing got derailed at the trial court on sexual preference and so forth, I have no idea. Because this constitutional clause simply talks about sex. And that's all it talks about.
I tend to think that you're right about that, but I still ask the question whether the classification is as you describe, or whether the fundamental classification at issue on these facts is a distinction between those who could marry at the time and those who could not.
No, I submit that it's. I do not believe that is correct. Given the definition of domestic partner in the administrative regulations, it doesn't really matter marry or not marry. If she had been living with another woman
at the important moment in the chronology of this case, please correct me if I misunderstand the sequence, but at the important moment wasn't the law that domestic partners of the same sex could receive the benefits.
Yes, sir.
And at the same time, domestic partners of the same sex could not marry.
Correct.
And so, under compulsion by the federal courts, the state made, if you will, an involuntary decision to say anybody who can marry can confer benefits, and certain people who can't marry under the then existing law can confer benefits.
Yes.
Isn't that the operative classification?
No, because she didn't really fit in that mold. She could have gotten married to Christopher Kutcher if they had wanted to do that. Neither one of them wanted to be married. They wanted to raise their children.
But that's why I asked the question. Neither one of them wanted to be married, and that's a requirement to confer benefits. Even today, when all of this is essentially a legal anachronism, state employees who choose to have domestic partners of any gender cannot confer those benefits. The state has drawn a classification between those who are married and who are not.
That I don't know. What I know that is in this period, if you were of the same sex, married or unmarried, you could, based on the injunction, you could get these benefits. But if you were of a different sex and you were unmarried, you couldn't get them. And the only reason is your sex. Change the sex and everything changes. So, I mean, the trouble is there's a fog in the background. And, of course, once we step into this fog of sexual relationships and sexual preferences,
well, I agree with you that
people get
I don't
lost.
think sexual preference has anything to do with this case.
Then I've won. I mean, the case is over because it's just about sex. It's about nothing else.
I'm not sure I follow that.
I hope that you might. No, because all this clause is talking about is sex. And it's solely and exclusively because of her sex that she couldn't get the benefits.
Not because of her choice not to marry.
Whoa. Now there's an interesting question. Yes.
She could have gotten the benefits had she chosen to marry.
Had she and her partner together chosen to make one of the most private decisions that any couple can possibly make to get married.
Which affects people's fundamental aspects that are fundamental to people's lives across the spectrum of activities.
Absolutely.
Whether it's taxation, property ownership, child custody, state interference with child rearing. There are all sorts of ways in which that decision is a choice to acquire some rights, perhaps to give up some rights, and people can voluntarily make that choice or not.
Well, first comes the choice, and then comes all the ramifications from the choice, right. All the benefits and burdens that come with that sort of choice. But here, the state's position has been, well, you just solve the problem, get married. But you can't force people to get benefits like that by saying that your individual preferences on whether you want to get married or not don't matter. If you want to get these benefits, you have to get married.
Well, today that's the law, right? I mean, today, if you have a domestic partner of whatever gender, you may choose to marry or you may not choose to marry. And if you choose to marry, there are benefits available, and if you don't, there aren't.
That I do not know, because I did not...
Let's assume then that that's a hypothetical.
All right.
It's a hypothetical, fairly well grounded in fact, but it's a hypothetical. Is that unconstitutional?
Could you distill the hypothetical a little bit, and then I could probably answer it better?
I can repeat it. I don't know if I can distill it.
All right.
Today's law is that married state employees have some benefits that unmarried state employees don't. Today's law also is that gender is not an impediment to marriage. Do we
Okay.
agree on that? Is today's state of the law unconstitutional?
I do not think it is. Assuming that your hypothetical is correct, I do not think that that would be unconstitutional.
So when the state involuntarily accepts a command from the federal court sort of creating the next best thing to marriage as a way of getting benefits, is that a legislative decision by the court that constitutes state action for purposes of constitutionality?
If I understand the question correctly, in reaction to the injunction, the state decided to provide these benefits to same-sex couples and didn't really care what happened to different-sex couples if they're unmarried. The state had a choice at that point. When the injunction came down, it of course, followed the injunction or appealed. They appealed and they lost. So they followed the injunction and provide the benefits to same-sex couples. They also had a choice to say, hold it, we have a constitutional clause here that says we can't discriminate on the basis of sex, and what we're doing is discriminating on the basis of sex. And we can't do that. We can't violate our Constitution by doing that because we can't give to certain group same-sex domestic partners who are same-sex domestic partners. We can't give them benefits and deny them to others on the basis of sex. The state had a choice at that point. I don't think it's a legislative choice. I don't think it's an administrative choice. I think it's a constitutional choice. The Constitution forced the choice on the state to provide benefits to different sex domestic partners. And the state decided not to do that in violation of the Constitution, which is why we're here.
On the other hand, when the state decided we're only going to provide benefits to married couples and gender was then an impediment to marriage in some cases, that was held unconstitutional.
Yes.
So essentially there's a constitutional right to benefits.
Yes.
Is your position.
Article 2, Section 36, that's it. For this period, for Renee in relation...
Well, I mean, I think you would be saying for the period of 1912 up to, was it 2014, 2015? I think in Arizona it was 2014. For that entire period, there was a constitutional right to receive benefits regardless of marriage.
No, I would not be saying that.
Good.
Because this Article 2, Section 36 clause is not that old. It's a fairly modern invention. And it's designed to make sure that state employees receive equal benefits regardless of a whole range of things, a race, sex, color, ethnicity, national origin, a whole list of categories that can no longer be the basis for any sort of discrimination in state benefits to state employees. But that, going back to 1912, much as I admire our state constitution and its progressive nature, they were blind to a whole lot of things going on at the time. There was no women's suffrage, for instance, in our state constitution when we became a state. And I think anti-miscegenation statutes were still on the books. There was a whole bunch of things that the progressive era didn't get around to solving and wouldn't get around to solving once that rat Wilson got in office. But that's a different story. The point being that no, the answer to your question is no. This does not go back to 1912. This goes back to the foundation of this particular constitutional clause, Article 2, Section 36. And the period, of course, I'm interested in is the period that affects my client. I do not know, and I haven't researched what happened after that period. And while if I get a case that involves that, I will devote my attention to it. But I do submit to the court that the definition of sex in this constitutional clause and how the constitutional clause is analyzed in relation to sex is of extreme importance to our state's employees. It's a very simple. It's either the biological male-female sort of thing, or you wander into this fog and mist of sexual preference, sexual orientation, and away you go.
Well, then let's assume that your constitutional argument is correct. Have you effectively pointed out a defect in the federal injunction?
Well, you know, there was a newspaper article the day after the injunction came down, and they said, you know, this doesn't deal with different sex couples. Even the newspaper writer understood that there was a problem lurking here, and anybody who looked at it would say, yeah, there is a problem lurking. You deal just fine with same-sex domestic partners, but you left different-sex domestic partners out in the ozone someplace. But
well, that's what the injunction did. What the state did was simply say we're not doing domestic partners. There are no domestic partner benefits.
Well, they provided benefits to same-sex couples, and they didn't provide them to different-sex couples, married or unmarried. They didn't provide them
During the period before the injunction, but after the change away from domestic partner benefits. Was there a constitutional problem then? In other words, when the state says only married people can have benefits, and at that time gender was an impediment to certain marriages, was there a constitutional problem, or had the state drawn a valid classification based on marriage?
No. When in the sense of
no to which?
In the sense of marriage that is a man and a woman, there was a big constitutional problem.
Well, that's a separate issue, though. The benefit issue was if you're married, you get benefits. If you're not, you don't. And that's actually still the law today.
Well,
so before the federal injunction, which required the reinstatement of certain domestic partner benefits, during that interim, was there a constitutional problem with the state's position?
Yes, because it wasn't talking about it wasn't. The problem was the marriage clause was a legislative attempt to discriminate against same-sex couples who could not at the time get married. So
when was the constitutional provision that we're talking about today enacted? Roughly.
A few years before this.
Okay.
It had been on the books for the relevant period of time before.
Yeah. So a few years before this, if the state decides to say only people who get married get benefits.
The difficulty is that only certain kinds of people could get married.
Well, that's still
based
the case.
on their sex.
That's still the case, right? We do preclude certain types of people from getting married.
Well, if you're extremely underage and if you're too close in a relationship, I can't marry my sister, God forbid. You know, there's all kinds of restrictions there. But not. We're dealing here with a simple basis of sex because.
But under our statutes,
and that didn't.
Under our statutes, I think you actually could marry a close relative who was of your gender because you could demonstrate, which our statutes specifically contemplate, that it would be impossible for you to conceive children together. So
I don't know, but that's an interesting hypothetical.
But it sort of goes to my point that a classification based on marriage is no longer just marriage is not all inclusive even today.
No, it's not, and it never has been.
So are you saying that if your male cousin is your domestic partner, that you have a constitutional right to afford him benefits because you're a state employee?
No, because the way domestic partner is defined, if it's too close a cousin, you wouldn't be a domestic partner under the administrative regulations.
And those regulations are constitutionally valid in your view?
That's not my brief. I would say probably they're suspect, but as they say in Britain, that's not my brief today.
I'm afraid I've chewed up a lot of your time.
It's an honor having the time chewed up. Are there any other questions? I will take my seat.
Thank you.
Thank you.
May it please the Court. I'm Daniel P. Shack. I'm here with Ann Hobart. We are Assistant Attorneys General representing the appellees. The Court should not even get to the issues on the merits of the constitutional question before it. It has been the consistent position of appellate courts that they should not decide constitutional issues unnecessarily. In other words, if they can dispose of a case on a different point of law, they should do so. In this case, the statute of limitations clearly bars Ms. LONCAR's claims. The question here is when her cause of action accrued. And that, of course, depends on the sort of claim that she's making against the state, which, folds into the declaratory judgment relief. But as this court held in Canyon del Rio, the statute of limitations for declaratory judgment action is connected with the underlying sort of breach. So what happened here? What is she claiming? She is claiming that the state deprived her of a life insurance policy on Mr. Kutcher. When did that happen? That happened when subsection O went into effect in January of 2011. The statute of limitations for state claims under 12-821 is 1 year, and if she's stated any viable federal claims, it's 2 years under the personal injury statute, I believe 12-542. That's federal law. So when did she sue? She sued in 2016. She was late under either of those statutes. She had been injured in her theory of the case as of 2011 when she could no longer get a life insurance policy on Mr. Kutcher. Statute started running.
Refresh me, how long after the enactment of subsection O was the injunction?
I have that here. The preliminary injunction was entered on July 23rd of 2010, so that's actually before the statute became effective. Given that, the court shouldn't even address the merits of her constitutional claims.
I'm curious, if the case were timely, in your view, do you think that the Declaratory Judgment Act affords us the ability to consider, or the courts generally, the ability to consider the question? The reason I ask is there's no direct state equivalent of Section 1983.
Correct. I think that question ties up again with whether there's an otherwise available claim. The Declaratory Judgment Act cannot be used to revive a claim that has already died. I think that's the next step from cases such as Canyon del Rio, which say that there has to be an existing controversy. So if the statute of limitations on the coercive claim, as the way the court terms it, has expired, then there isn't an existing controversy between the plaintiff and the state, and therefore the Declaratory Judgment Act would not provide an avenue of relief for the plaintiff. If we get past the statute of limitations, as the previous discussion demonstrates, there just is no claim here. The plaintiff has conceded very strongly, very vociferously, that this is not a claim based on sexual orientation. She says it is strictly based upon sex, and that simply is not true. She was not denied benefits based on her sex. She had the same opportunity to have the benefits as would any male employee. The deciding factor was the relationship she had with her partner. That is not based on sex. That's based on sexual preference or sexual orientation. So, how? Because what the deciding factor is the type of relationship she entered into. If she were a male entered into a heterosexual relationship, that person would not have been able to receive the benefits. So males and females stand on the same footing with respect to subsection O, And
How does
therefore,
that have to do with anything with sexual orientation? One could take on a domestic partner, as Mr. Abney points out, without any regard to that factor.
and again, what's the deciding factor? It's not the employee's sex, because both males and females can decide to do that either way. What the deciding factor is the sex of the employee vis-a-vis the sex of the partner. That is not based on sex. That's based on, well, as she has clearly defined it, her argument is that merely because she was female, she was denied these benefits, and that isn't true. And that's the.
She had been male and decided to have a domestic partnership with the exact same individual, she would have had the benefits.
Yes, she would have, but that deciding factor there is the relationship rather than the sex of the employee, which is what.
Relationship is defined as a domestic partnership, not as a sexual relationship. I would hope the government would never even ask that question.
Well, the general, we have to view this in terms of the real world, and the vast majority of people entering into domestic partnerships are doing so because it's a loving relationship. But nevertheless, even if it isn't, the same qualifications are there whether she's a male or a female. And as she says, the whole point of sex discrimination is, are the benefits available on the same terms to males as they are to females? That's the binary choice that she has set out. And in this case, her subsection O does not differentiate between male and female as far as the sex of the employee is concerned. It's all. It requires further factors which take it out of the realm of the A versus B, sex, male versus female. And that leads inexorably to the equal protection arguments, which basically say that you have to treat similarly situated people similarly. And as you, Judge Schwan, pointed out in the argument, Ms. LONCAR was not in the same situation, was not similarly situated to homosexuals with their partners, because they did not have the opportunity to marry, and so the regulations were addressing a different point. She could have gotten married, as you pointed out, and she just chose not to. They evidently had their reasons and benefits for not getting married, but that doesn't mean that the state has to provide the benefits that they would have otherwise been entitled to had they not gotten married.
I guess the problem is that the case we're talking about, your argument rings a lot more persuasively under current law than it does under the law we're talking about, right? Because at this point, my understanding of current law is that no domestic partners get benefits of any gender, of any type of relationship, that unless you're married, you don't get the benefits.
That is correct. The regulations have been rescinded.
That makes it an easier case than the one we're actually hearing today.
I respectfully say that it's just as easy under this situation, because any discrimination was not based on a similar situation. The problem identified in the federal court action was that same-sex domestic partners were legally barred from getting married, and it was therefore unfair to impose the cost-saving measures on them as a suspect, well, as a disadvantaged group. That wasn't the term that the court used. It was an unpopular group. Renee LONCAR, by contrast, had the full legal ability to marry Mr. Kutcher. She just chose not to. So she's not similarly situated to those who were protected by the injunction, and therefore the equal protection arguments fail on the merits also. If there are no further questions, that's all I have.
No, thank you.
Thank you.
On the statute of limitations, I think I've briefed that pretty extensively. We are seeking declaratory judgment relief, preliminary injunctive relief, and 42 U.S.C. Section 1983 relief, and
Well, how can you seek 1983 relief based on the state constitution?
violation of, if you act under color of state law and violate constitutional rights, doesn't that make it a...
Federal constitutional rights.
I think it's under color of state law and violate, if I recall 1983 correctly, it's broad enough to bring in violations of state law.
I don't want to derail you from your statute of limitations argument, because that's probably more important than the question whether 1983 applies against the state constitution, but I think you might find that a tough sell.
If I find it a tough sell, given 1 minute, 25 seconds to go, I will sell something else.
Let's talk about statute
All
of
right.
limitations.
My colleague across the aisle said she was not denied benefits based on sex, and she was. If she had been a different sex, this had been a different story. The deciding factor is not the employee's sex, but it was. My colleague says the vast majority are entering into these relationships because it is a loving relationship. Well, maybe yes, maybe no. Maybe people were entering into these domestic partnerships because it made economic sense, and they liked each other, and there was a program available under the state, and they want to take advantage of it. And there's nothing wrong with that. The notion that she could have cured all the problems by getting marriage, I believe, is an incorrect notion under constitutional principles. You can't force people, you should not force people to get married just to get benefits as your only avenue to get the benefits. Under this is an amazing constitutional clause. I was surprised when I ran across it in the context of this case. It provides very strong protections that you don't really get this specific anywhere else. If there's no further questions, I will cede my remaining seconds to the court.
Thank you, counsel. We'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.